He entered halfway into the shoulder and then jerked back into the lane. After previously having just gone through a green light. So there's no indication that he's allowing a vehicle to pass or anything like that. He went through a green light, entered the shoulder, and then jerked back.
So by your theory then, any single person...
VU. This is where the defense starts playing chess with the law, arguing that just touching the shoulder isn't enough for a traffic stop. But here's the question. Was it just a harmless drift? Or was it probable cause for something much bigger?
Person that ever drives a mere nanosecond to the right of an improved shoulder is now violating this offense, this transportation code. This law can't be like that.
Why, yo. Notice how quickly things escalate. A simple lane drift turns into a full DWI investigation, slurred speech, bloodshot eyes, and then the kicker, a breath test that comes back at 1.2. That's more than twice the legal limit. At this point, the just a drift defense starts looking shaky.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28, 2024, the officer came to a stop behind the defendant's vehicle, and the light turned green, and the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage, and standard sobriety tests were administered. HGN 6 out of 6, the walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
VO. This is huge. The ignition interlock is basically a breathalyzer wired into your car. You can't even start the engine unless you blow clean. It's the judge's way of saying, I don't trust you on the road without a babysitter. And he makes it crystal clear. Violate it, and you're back in jail.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's eligible, Your Honor.
All right. How many prior DWIs does he have?
He has one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you're not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance. But
Here's where it gets spicy. The defense is dissecting the statute line by line, saying, look, the law allows 9 reasons for being on the shoulder, none of which were mentioned by the officer. This is classic defense strategy. Don't argue the facts, argue the technicalities. But will the judge buy it?
you must stay in touch with Mr. Stewart, and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel, and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're gonna have you wait for him now, but after today, I'm gonna waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right, I'm gonna have you sign a reset. I'll have you meet with Fleischer for bond conditions, and we'll just have you waiting back for Mr. Stewart to show, okay? Please.
Right this way.
Moments later.
Ready?
Yes.
Come on up.
Good morning, Your Honor.
Hey, how are you? Mr. Stewart, what's new?
Yes, sir. How was your New Year?
Great. We did PC on your case.
Okay.
We just did stand up. What's your guy's name again?
My last name is Allen, Your Honor. I would like to make an argument on PC. I don't know whether.
Absolutely. I'm always ready to hear it. So refresh my memory. What happened?
So in Allen's case, it was where the officer came to a stop behind the defendant's vehicle and the light turned green. The defendant,
But he had expired registration, right?
No, Your Honor. In this case, the defendant's vehicle proceeded through the green light and immediately drifted approximately halfway onto the shoulder with other vehicles around it and then jerked back into the lane.
Were there any other vehicles around when this happened?
Yes, the officer explicitly wrote there were other vehicles around the vehicle before the driver jerked back in the lane. So he went into the shoulder and there were other vehicles.
Go ahead.
Yes, sir. My argument is, Your Honor, that, as far as what's actually alleged, says the light turned green and the truck along with several other vehicles proceeded, which obviously is in compliance with the law. The only argument that the state has made here, elucidated, is that they observed a Silverado drift into the shoulder with other vehicles around it. If he's drifting into the shoulder, that's not endangering any other vehicle. That's not an allegation of the safety of anybody else out there on the roadway. The shoulder is away from any other vehicles. Maybe
The judge is really drilling down here because the law doesn't punish perfection, it punishes danger. Did the driver's drift actually endanger anyone? Or was it just sloppy driving? This fine line is where many DWI cases live or die.
he's doing this in an abundance of caution. There's no indication that it was dangerous or endangered any other vehicle, anything like that within the allegations here. Furthermore, there's numerous reasons why a vehicle is 100% legally allowed to drive in the right-hand shoulder of a vehicle. I think there's 9 reasons in the state of Texas why a vehicle is allowed to drive in the shoulder. There's nothing here that alleges that basically he committed any sort of crime that would lead the officer to then stop him. This is insufficient information, and I would argue that there's not valid probable cause here on this case.
I think he has a valid point where, perhaps he's, I don't want to speculate, and you're saying, well, maybe he did it because of this, but I don't want to speculate, right? Because were there other cars? I don't know. Was it dangerous? I don't know.
Judge, but failure to maintain a single lane when there are other vehicles within the vicinity is a valid reason for a stop.
Right, but you got to articulate facts as well, right? So according to the statute.
Right, and I understand because we've had this issue before where it's failure to maintain a single lane, but we're unsure if there's other vehicles. That I can appreciate and understand. But in this case, the officer did specify that there were other vehicles in the vicinity. And under Texas law, that is sufficient for a stop.
I disagree. I think that when we look at the statute for trying to maintain a single lane, the second half of the statute is that it endangered somebody. And there's no indication here that there was any danger.
Was it 545.460? Isn't that it?
Fleming, Harden.
545.060, Your Honor. Section A2, may not move from the lane unless that movement can be made safely. Shall drive as nearly as practical entirely within a single lane, and 2, may not move from the lane unless that movement can be made safely. There's no allegation here that the movement was made unsafely, or that there was
Judge,
anything unsafe.
I also have the list of, where under Texas law where it's permissible to drive on the shoulder, to stop, stand, or park, to accelerate before entering the main lane of traffic, to decelerate.
Let's do this. This is going to take quite a bit of more time. So can you come back? Do you have anywhere else to go?
Oh, yeah.
Let me go through the arraignments, get everybody done and out of here, and then because this is going to take quite a bit more time.
Yes, sir.
Right? And then give you time to take a look more, so if you need to, you too as well, if you want to try to find case law. Let me just go through, because I have another lawyer that's waiting,
Absolutely.
Yeah, I'll help you out, but let me get through everything. Yeah, for sure.
Just the sheriff's and prosecutor. Good morning again.
Hey.
I wanted to reapproach regarding the PC on Mr. Allen's case.
Okay.
I know the state has emailed me some cases that they wanted to cite to.
Morgan.
Here's the prosecution's counterpunch: case law. By citing past rulings, and they're arguing that drifting onto the shoulder itself is enough for a stop, unless you have one of those 7 legal reasons. And since none applied here, boom, the stop stands. This is why courtroom battles often turn into a duel of precedents.
Judge.
I don't know whether someone else wanted to speak to that.
Yeah. If we may, upon reviewing case law, so as we've discussed before, so he did veer into the shoulder and then go back onto the lane. And in Hardin, failing to maintain a single lane with the added vehicle component is the danger that they provided in the case law that makes failure to maintain a single lane, unlawful. Furthermore, in cases such as Lamming and Martinez, the court added additional factors to consider for the officer into determining whether or not failing to maintain a single lane is unlawful. And one of those is the time component. In Martinez, it was at midnight or at 1 o'clock in the morning. Here it was midnight as well.
No, but one of the things is there's an element of unsafetyness, right?
And Your Honor, there are other vehicles around. As the officer articulated in the dims, there are other vehicles around when he veered and then jerked back into the lane, as the officer put in the dims.
But I get it.
And then,
But where are the other vehicles? Are they next to him? Are they in front? Are they in back? He doesn't articulate it. All he says is there are other vehicles.
and furthermore, Your Honor, what he did articulate into the shoulder, and upon looking at the statute for that,